Over the lunch hour, I read plaintiff's deposition. He made an allegation that he saw some of the workers drinking beer. There's no relevance to any of that testimony. I want to make sure that nothing of that nature gets blurted out at trial.
Presidents?
No, I think if they're drinking while they're doing the job and they do the job poorly, I think that goes to their performance. If they were under the influence of alcohol, I don't see how that's not relevant.
There is no evidence that any of the workers were under the influence of alcohol.
Do you expect to bring this out at your examination?
He saw them drinking while they were working, throwing beer cans on the floor.
Well, I guess it affects their ability to do the work, doesn't it?
There is no issue as to negligence. It's strictly a breach of contract case. And there is no...
Is workmanship an issue?
Well, that's what we're arguing. Yeah. There was poor workmanship. And that's the breach.
Well, there's no pleading that brings out an issue of poor workmanship. It's strictly a breach of contract. Is there a contract? Is there a breach? What are the damages that logically flow from that breach? And the issue of alcohol is so inflammatory that without corroboration in the form of other evidence to show that someone was under the influence, that the inflammatory nature of the evidence outweighs any probative value.
Well, what about cross-examination? Can't you get into it on cross-examination?
I guess that's my only remedy if the court won't grant my motion in limine.
I mean, if there's a question with the workmanship, the workers weren't working in a responsible manner, I guess that's an issue they have a right to bring out.
If there is competent evidence, and we submit there is no competent evidence of intoxication or impairment.
Well, I mean, are you alleging that they were intoxicated?
He didn't give them a breathalyzer. He didn't give them a field sobriety test. He saw they were drinking while they were working.
Saw them drinking a beer.
He threw a six-pack in the backyard. Empty can.
Sir, you're not to address the court. I'm addressing your lawyers.
He noticed them drinking while they were up there, and they were throwing the empty cans into the backyard. I mean, but he didn't examine them. He didn't conduct any type of test of them. He can't testify that they were intoxicated
or impaired.
That's cross-examination. All right. Overruled.
All right. Now the second issue has to do with what the court has already ruled in terms of the defendant's motions in limine in regard to the wealth of the parties, the plaintiff's disability and medical conditions, and whether or not the plaintiff is on disability. All of these motions in limine were granted by the court prior to trial. In the plaintiff's opening statement, he made reference to the fact that the plaintiff cannot afford to fix his home, which is in direct violation of the court's motion in limine. So even though we didn't object, because I didn't want to call any further attention to the
you don't want it to go any further?
I don't want it to go any further, and I asked the court to enforce its own ruling in regard to the wealth of the parties and any disability the plaintiff has from the Vietnam War or otherwise.
Well, Mr. Vesnos, I guess, does the jury have a right to know whether he's employed or not?
I'm not sure how that's relevant to any of the issues of the contract.
Anything, Mr. Vesnos?
I mean, You know, if they're going to argue that he failed to mitigate his damages, then I should be able to bring up why he couldn't fix the roof.
We may ask whether or not any work has been done to the roof since it was completed in January of 2008. That in no way is relevant to mitigation, and I think there really is not an affirmative defense of mitigation. There's no evidence here to show mitigation. But the court's already ruled on these matters. We prepared our case based on the court's rulings. And for him to bring out at this point that he can't afford to fix the roof and he's disabled and he's a Vietnam vet is directly contrary to rulings the court already made.
I won't bring it up.
Don't bring out the can't.
I won't bring out anything. But if they start arguing failure to mitigate, then I think they open the door.
Okay. Fair enough.
All right, so the court's rulings remain the court's rule.
Court rule. Court rule. Okay.
That concludes my two matters, Judge.
Bring them in.